We're going to split the talk into 4 sections. Miles is going to give the introduction. I'm then going to talk about some issues arising from common wordings generally. Miles will have a look at the minimum terms and conditions for solicitors and some issues specifically arising out of those. And then I'm going to wrap up just by looking at where things stand after discovery land. We've got a slot for an hour. We'll try and finish after about 50 minutes or so, and then time for questions at the end. So I hope that works. Over to Miles.
Thanks, Graeme. Okay, so I'm going to start with just some general principles relating to aggregation, and a starting point, as so often, is the common law. And at common law, the insurer's position is that they're liable for successive losses, even if that means a total amount of such losses exceeds the sum insured under their policy. And that's something which is expressly set out in the Marine Insurance Act, which says that unless the policy otherwise provides, the insurer is liable for successive losses, even though the total amount of such losses may exceed the sum insured. So absent any provision to the contrary, if you're an insurer who insures a property that's worth 100 grand and has a sum insured of 100 grand, if that property is destroyed twice in the policy period, you're paying £200,000. Or to take another example, which has been keeping the court busy in recent times, if you have a non-damage denial of access business interruption policy, and it's got a £50,000 sum insured, it's shut down 3 times in the policy period, you could be liable for £150,000. And it won't take you long to see that the potential problems of that principle in any form of insurance, but professional indemnity insurance in particular, are obvious. So an insurer providing cover with a £1 million limit of indemnity to an accountant could face exposure of up to £100 million if that accountant is said by 100 claimants to have been negligent and caused them to invest in a tax avoidance scheme because of the same accountant's advisory memorandum, or a single memorandum. And obviously the fact that the 1 million limit of indemnity is per claim in most professional indemnity policies would make it even clearer. One doesn't necessarily have to resort to the common law or the Marine Insurance Act. So absent contractual wording to the contrary, the other important point to note is that similarly unattractive consequences follow from the fact that the professional indemnity insured is normally self-insured, has a large excess or deductible that's also payable per claim. So again, to give an example for those of you less familiar with that, take an accountant who has a £50,000 per claim deductible, facing 100 claims, they might have a bill for £5 million from their insurer. So these are the kind of problems that mean aggregation clauses have to exist, and they are contractual provisions that seek to modify the common law position and address those problems. And the purpose of them was summarised by Lord Hoffman, adopting something to be said by Morbeck at first instance in Lloyd's TSB. He described them as their purpose being to enable 2 or more separate losses covered by the policy to be treated as a single loss for deductible or other purposes when they are linked by a unifying factor. Unsurprisingly, given the common law position, if there isn't an aggregation clause, the court isn't going to imply one to achieve that purpose. Now, Graeme's going to look at different kinds of language that are used in aggregation clauses, and as that review is going to demonstrate, there's no single type of aggregation clause, and the scope's always going to depend on what language has been used, and that language in turn reflects either the bargain struck by the parties, or in the case of compulsory insurance with lots of professionals, that's going to be the case, the outcome of negotiations, give and take, between the participating insurers and the regulator. But the clauses can vary from being very simple clauses to much more complicated ones. So a simple clause, the aggregation clause, would be the kind that, say, applies a £1 million per has a £1 million per loss policy, but provides that it shall not exceed £2 million in aggregate in the policy period, or of the kind that was in Spire Healthcare and RSA, where there was a provision, a limit in respect of all damages arising out of all and any claims during the period of insurance, irrespective of the number of claims and whether they're connected in some way. So one can see that those types of clauses are straightforward. They don't depend on any unifying feature beyond the fact that the claims or the loss are sustained within the policy period. But the kinds of clauses that Graeme and I are going to spend more time focusing on today are more complex and cause more difficulty. And in these cases, the unifying point or unifying factor isn't simply a period of time, but some shared origin in an act, an event, an occurrence, or a cause as specified by the relevant clause. And the more general the description of that shared event, the wider the scope of the policy, obviously, and the more likely insurers are going to be able to aggregate. And as so often in any type of insurance law, determining what the clause means is a combination of first principles construction, guided by what previous cases have said. But some points of principle are of particular relevance to aggregation clauses. The first is that aggregation clauses should be read neutrally, unlike an exemption clause, for example. And that was stressed by the Supreme Court in AIG and Woodman, a case where I'll return to later, as being the correct approach because, as my examples I've referred to show, these are clauses that can benefit insurer or insured depending on the circumstances. But also because the give and take of compulsory insurance is trying to balance always the need to protect the public with the cost and availability of cover, or at least that's the principle stated in Supreme Court. Whether that is so may be something that others disagree with. The second point of principle is that although policies often seek to group claims together for the purpose of determining both the deductible and the sum payable by insurers, there isn't any presumption that that's the case. So you may have a situation where you could have one deemed claim for the purpose of the policy limit, but multiple excesses or deductibles payable. It all depends on the way the lower clause has been drafted. So for that introduction, I'll pass over to Graeme for the next part of the talk.
Right. So, as Miles has said, the touchstone for every entitlement to aggregate is going to be the existence of one or more unifying factors. And what we're going to do, and it is going to be both of us, because I'm going to look at one aspect, Miles is going to look at the second aspect, is to look at how different policy wordings can require different unifying factors to exist as a precondition to aggregation, and what those policy wordings are going to mean in practice. The reason that we're going to split it in two is because you can broadly split the types of unifying factors in two and describe those as horizontal connections between the claims and vertical connections between the claims. And what does that mean in practice? Well, consider a fairly typical wording that provides for the aggregation of similar claims arising out of related occurrences. And that wording has got both a horizontal element and a vertical element. As far as the horizontal element is concerned, what you're looking at there is a connection between the claims themselves. So in the example of wording I gave you, the claims would need to be similar to one another to aggregate. And then there's a further horizontal connection that exists between the underlying occurrences from which claims can permissibly arise if those claims to be aggregated. Again, in the wording that I gave, the underlying matters or the occurrences have to be related to one another. And so what we're looking at for horizontal connections is links across the claims themselves or the layer of claims, links across the layer of underlying causes, and quite possibly in many aggregation wordings, links in both respects. And that is something that does arise frequently in the context of the MTCs, and so Miles is going to be looking at that. I'm going to look at vertical connections. And again, there's really two issues that arise. A vertical connection is the link that the policy wording is going to require, firstly, between the claim or the cohort of claims that you want to try and aggregate or want to try and avoid aggregating, and then, on the other hand, the route from which those claims are said to arise or whatever other form of wording might exist. So again, going back to the same example, similar claims that arise out of related occurrences to be aggregated. When we're looking at a vertical connection, we're looking at two different words than we're looking at for the horizontal connections. The first is that we're looking at occurrences, similar claims that arise out of related occurrences. So we're looking at the route. What's the nature of that route? What must it be in order to move on to the next question of, well, do the claims arising out of it in fact aggregate? And as we'll see, different policy wordings require different types of route to exist. And then the second element of a vertical connection in the wording I've given is arise out of, similar claims that arise out of related occurrences. and what we're looking at there is the causal link between the layer of underlying root and the layer of claims themselves, and again, different policy wordings. So looking at each of those in time, looking first at the underlying root, there's 5 up there. Far and away the most common are the first two, an occurrence or event on the one hand, and then a cause, originating cause, original cause, source on the other. And to save anyone being in too much suspense, the courts have generally said that all of the ones in the second box mean roughly the same thing. But there's a pretty serious distinction between the first two, certainly. Occurrence or event is one of the narrowest wordings out there, and it's certainly narrower than a cause or originating cause. In AXA and Field, the House of Lords said occurrence or event, it's something that happens at a particular time, at a particular place, and in a particular way. So you're looking at the actual factual occurrence, the event, the occurrence. You're not looking at the underlying reason. You're not looking at why the event occurred. You're not looking at the cause of the event. So using an example that we'll be coming back to when we look at some of the solicitors' cases, employee steals repeatedly over a long period of time. Using this sort of wording, each theft will be a separate event or a separate occurrence. The fact that underlying that each theft might be a strand of dishonesty is neither here nor there on this particular wording. And the most common issue that arises when we're looking at occurrences events is it's fine when we're looking at a single event or a single occurrence, but what we're looking at is whether or not the underlying cause of multiple claims will be a single occurrence or a single event, or multiple events or multiple occurrences. And the courts generally, in the way of these things, advocates a common sense approach, using two examples that at first blush you might think sound quite similar. In fact, when you stand back, you can see the distinction. Seizure of the airport during the Iraqi invasion of Kuwait, loss of multiple aircraft. What did the loss of the multiple aircraft arise from a single event? Yes, it did. It arose from the taking of the airport. Again, look at 9/11, and in particular the two planes going into the World Trade Center. Was that a single occurrence? On the face of it, the judge who looked at it in the first instance, Mr. Justice Field, said, well, they did occur at very similar times, in the same place, in the same way, so they met the AXA criteria. But actually, if you step back and look at matters not from the point of damage, but in the round, you can see that actually the event or the occurrence from which the claim arose was the hijacking of each plane and the consequent crashing of each plane. So I'm going to skip to bottom left, act or omission, simply because that is very conceptually similar to an event or occurrence. It's a slightly wider form of wording for one reason. An act will generally be construed in the same way as an occurrence. It's something positive. Omission is obviously the lack of an occurrence or the lack of an event, and so it widens things out in that respect. It does, however, require something more than just an absence of an event or an absence of an occurrence. You can look at it in terms of an absence in circumstances where either there was an expectation that something would happen or even an obligation to make something happen. Turning therefore to cause and all of those type wordings, unlike events or occurrences, causes are not concerned with the losses themselves or even with the underlying events, but rather that you're looking at the underlying reason for the underlying events. So Countrywide Assurance and Marshall, the word event or occurrence describes what has happened. The word source or cause describe why something has happened. So fair example, earthquake results in destruction of a dam, results in widespread flooding, results in damage to a property. The event or occurrence might be the damage to that property. The cause may be the flooding, it may even be the earthquake, and you can see straight away if you put it in those terms, claims that can arise from one or other of those have got vastly different scope. Two other areas where causes can give far wider scope than events or occurrences. Causes can be a continuing state of affairs. There's some of you'll remember Cox and Bankside, the underwriter who Colin very kindly put it in terms had a blind spot in his knowledge. actually he was found to have had no appreciation of the nature of the business he was underwriting. But that state of affairs was sufficient to amount to a cause or originating cause. And similarly, an event or occurrence is unlikely, as we've discussed, to be the absence of something happening, but Countryside and Marshall, it most certainly can be the absence of something for the purposes of cause. In that case, the cause of the claims was the absence of any training that was given by the employer to their sales agents. I'm going to turn very briefly to Spire Healthcare in this context. It's something that we'll come back to a little bit later. Miles mentioned it earlier as a fairly straightforward source of wording. The wording in that case was aggregation of claims consequent upon or attributable to one source or original cause. Many of you will remember that was a case where a surgeon had, for a dozen or so years, performed unnecessary operations. He'd done them without informed consent, and underlying it all was a desire for financial gain. Group litigation took place against Spire, his employer. The operations fell into two broad categories, 1 and 2. The claims ultimately against Spire came to in excess of 30 odd million, including costs. Spire's insurance policy had a £10 million limit. Was it one pot or was it two pots, one for each of the two categories? And the Court of Appeal had no hesitation of saying that sort of wording, you are looking at one limit. All of the claims were consequent upon the same source. And Lady Justice Andrews was pretty generous in identifying 4 different sources from which all of the claims could have arisen. At the highest level, she simply said the surgeon himself. Working it down, the surgeon's dishonesty, then his practice of operating without informed consent, and then his disregard for the patient's welfare. So you can see it's a pretty high level approach. And actually it's Spire as well that confirms that source is to be lumped in with cause, originating cause, and the like. Just before I move on from cause, just be a bit careful to distinguish between cause on the one hand and cause of action on the other. Claims arising from a single cause of action is very different to claims arising from a single cause. A cause can obviously give rise to multiple causes of action, and so that's the difference. We then move on to a couple of wider wordings. State of affairs, certainly wider than a single event or occurrence. A state of affairs is actually what results from one or more events or occurrences, and as a result that has been interpreted really very widely. And lastly, accident. It's not the most common of wordings these days. I raise it because it can be a bit of a googly. An accident, the Court of Appeal have told us, is a specific incident, not a state of affairs. So far so good. You would think therefore that if two vehicles collide, that's one accident. Not so. There's a line of authority that says that actually if two people are injured in that collision, that is two manifestations of loss, and that counts as two accidents. And because I still struggle to get my head around that. But it's a little bit easier if you look at it in a slightly different context. There's a case called Tioxide and CGU, where Tioxide manufactured pigments. The pigments were used to make white UPVC. The white UPVC went into windows, and in certain climatic conditions it all discoloured. And there the court had to consider, well, actually, what is, and the policy there was triggered by, the aggregation clause related to accident. Was it one accident? Was it multiple accidents? And the courts actually said it's pretty plain, it's multiple accidents here. Each use of tainted UPVC arising from each use of pigment counts as a separate accident. And I confess I do find that a little bit easier to understand than the car crash one. Quick wrinkle. We've been looking at claims arising out of an event or a single event. You can get them arising out of multiple events in some wordings. The wordings tend to fall into two categories: claims arising out of the same events or claims arising out of similar events. Same event speaks for itself. Similar events is obviously more latitude. Certainly my experience, the judge works out what results he or she wants to reach, and then says they are or they are not sufficiently similar or different in this case to reach that result. Just a word of warning. So turn from the underlying unifying root to look at causal link. So what we're looking at now is what needs to link the claims and that root. You can see, oops, sorry, got one too far. You can see again, oh dear. We've got, 8 different wordings up there. You'll be pleased to know we're not going to go through them all. But the one thing they've all got in common, it's an objective standard. That is pretty much where the similarities stop, unfortunately. The default position tends to be If it doesn't say anything else, you need to show that the event, occurrence, cause, etc. is the proximate cause of each claim. What does that mean? Well, start with what it doesn't mean. It used to be thought that that means it had to be the last in the chain of events. No, not anymore. Used to be thought that maybe that it had to be the sole cause or even the dominant cause. No, not anymore. Really, it means nothing more than showing an adequate legal and factual connection. And it's from that starting point that the question then tends to arise, okay, how does that test differ if we move away from proximate cause to any of the other causes? We go first to caused by. Well, we've taken the word proximate off. Some courts say it doesn't make any difference. Other courts seem to say, well, actually, it's slightly weaker. Maybe we're just looking at a but-for test or a factual causation test rather than bringing anything else in. Arising out of, not the easiest to give any guidance on, because you've got a strand of authority says that it's a narrower wording than proximate cause. Then there's an equal strand of wording, begins with Kojima, that says it's potentially wider than proximate wording. And then in Beasley and Travellers, the judge said, well, it all depends on the context. So work that one out. As a consequence of, or the consequence of, again, not straightforward. You've got Commonwealth authority suggesting it's wider than proximate cause. Then there's a couple of English authorities, one very old, one from the 70s, that suggest actually it means the same as proximate cause. Resulting from, Lloyd's TSB addresses this. Miles is going to have a look at that in a slightly different context. But at first instance, it's Mr. Justice Morbick, I think, wasn't it, said that actually meaning is going to depend on the construction of the policy as a whole, and it may or may not be an expression of ordinary proximate cause. Court of Appeal disagreed and said, no, it's going to be a proximate cause. Turn to the bottom row. These are all much wider wordings. Attributable to, there has to be some form of causal connection there, but in Australia it's been interpreted as being can be attributed to, so there can be multiple other causes, but this could be one of them. In connection with, we're getting very weak indeed now. There's a good New Zealand case which illustrates it quite well. Insurance broker negligently fails to place property damage cover. He then dishonestly tells his client that he has got such cover. There's an earthquake, property damage ensues. The homeowners try to claim on their non-existent policy and end up suing the brokers for not obtaining cover for them. The broker's PI policy excludes cover for liability incurred in connection with dishonesty or in connection with fraud. And New Zealand Court of Appeal said, bad luck, that is a claim in connection with fraud, in connection with dishonesty. They didn't find it was a negligence one. I'm not sure that we get the same result over here. But anyway, it shows quite how weak that causal connection must be. And then likewise, in respect of, and then probably weakest of all, in any way involving, I mean, that last wording is pretty rare, and you might not even need any causal connection at all there. There just has to be some way of seeing the two in the same context. Couple of wrinkles. Directly or indirectly sometimes appears. If the word indirectly in there, it obviously widens the scope for a causal link. You might think that actually if the word indirectly is not in there, well, that means directly. Yes, it does. For some reason, certainly in my experience in arbitrations, if directly starts appearing, courts seem to be even more demanding, or arbitrators seem to be even more demanding. It shouldn't be, but that sometimes just seems to be the approach. And then concurrent causes, a talk in itself, but you've got two distinct scenarios. First, where there's two events, let's say two causes. Firstly, they can be independent of each other, and each independently can be capable of causing the loss. Or you can have the situation where event A leads to event B, which leads to the loss, and actually the loss wouldn't have occurred unless both of those happened. And then in each scenario, you're then looking at obviously one insured peril, one uninsured peril. Is it truly an uninsured peril or is it an accepted peril? And in each of those, four different types of scenario, you're probably going to end up with a different outcome. And that is, as I say, a talk amongst as itself. Two final wrinkles on this particular matter. You will see from time to time wording each and every claim, each and every claimant. It tends to arise in the context of aggregation clauses, in the context of deductibles. Miles touched on earlier that courts generally will try to interpret aggregation clauses and an aggregation of deductibles in the same way. It doesn't always happen. If the wording says it shouldn't happen, the courts will find it doesn't happen. There's a case, Standard Life and Oak Dedicated, that you almost end up feeling sorry for the insured. Endowment mis-selling case bought by 97,000 people, investors who had bought mortgage endowment policies, claim worth in excess of 100 million, each case being worth about £10,000. Liability policy provides limited indemnity of 75 million over 25 million, and the deductible is payable by the insured each and every claim and or claimant. And the deductible aggregation wording is different from the claim aggregation wording. Judge found claims aggregate, so it's a single claim worth effectively the policy limit, but each the deductible payable under the policy applied to each and every claim or series of claim brought by a single claimant. And so multiple £10,000, well, multiple deductibles applied, meaning that it fell to the insured to meet each and every one of the £10,000 claims themselves. And last word from me before I hand back to Miles. Miles referenced the fact that some aggregation clauses are simpler than others. Mr. Justice Eder in Standard Life and Ace European is a good place to go if you ever want to see something really complicated. He said that this aggregation wording was as wide as he'd ever come across and wider than he'd seen in any reported case. All claims or series of claims, whether one or more or one claimant, arising from or in connection with or attributable to any one act, error, omission or originating cause or source, or the dishonesty of any one person or group of persons acting together. I think if you're acting for an insured, that is your gold standard. If you're acting for an insurer, avoid it at all costs. So.
Okay, thanks, Graeme. So to pick up some of the threads Graeme's looked at there, and to set the scene for Graeme looking at Discovery Land, which is obviously on our billing of our talk, I'm going to look at the minimum terms and conditions briefly. Now, the current minimum terms, as many of you will know, has minimum as indemnity limits for any one claim of either £3 million or £2 million, depending on whether the insured's a relevant recognised body or a relevant licensed body or not. But it allows the insurers or the insurance to provide that when considering what's to be regarded as one claim, then for the purpose of those indemnity limits, then all claims arising from one act or omission, 2, one series of related acts or omissions, 3, the same act or omission in a series of related matters or transactions, or 4, similar acts or omissions in a series of related matters or transactions, and all claims against one or more insured arising from one matter or transaction. All of those will be regarded as one claim. So one can see a lot of the words Graeme's taken you through there in that one clause. And this clause was adopted 2 years after the House of Lords case in Lloyds TSB and Lloyds Banking Group, which is in 2003. And it's a little wider than its predecessor in that it added the little Roman 3 and little Roman 4 clauses. And under this permitted aggregation clause, insurers are allowed to aggregate 2 or more claims if it can be said they arise from one or more of the circumstances listed. And the indemnity limit then will apply regardless of the fact that the insured may face a large number of claims in aggregate exceed it. So Graeme's already looked at arising from and other causation features. But what about the other unifying factors that are identified in this clause? Now the unifying factor in clause 1, that's one act or omission, or in B, where you've got one matter or transaction, is pretty self-explanatory. More difficult are 2, 3 and 4, and those of what have concerned the courts in the cases I'm going to look at, and 3 and 4 in particular in Discovery Land. So starting with 2, when will the court consider that there are 2 or more claims arising out of one series of related acts or omissions? And now this is the same phrase that was examined by the House of Lords in Lloyds TSB before this clause was amended. The only difference being that that clause in Lloyds TSB said a single act or omission, then open brackets, or one series of related acts or omissions, close brackets. So the phrase one has in Little Roman 2 was in brackets, but otherwise it's essentially much the same. Now Lloyds TSB arose out of a situation not dissimilar to one Graeme's referred you to, where one had 22,000 claimants against TSB, all alleging they'd been missold pension policies, there'd been breaches of an obligation to give the best advice to them. TSB claimed an indemnity under their insurance policy. The only problem was that it had a deductible of £1 million for each and every claim, and no single claim exceeded £35,000. So they tried to get around this by arguing that the aggregation clause applied because the claims all resulted from a single act or omission or related series of acts or omissions. And they had some luck before the Court of Appeal. The Court of Appeal rejected an argument that the claims resulted from a single act or omission because the language of the clause they felt meant that the relevant act or omission here had to be the one that constituted the cause of action. In which case here it was the actual giving of the advice in each of those instances. Similarly, the act, if one's talking about a theft, the act of theft. However, the Court of Appeal did accept TSB's alternative argument, which was that the claims all fell within the aggregation clause because they were a series of related acts or omissions. And the relationship here being the single underlying cause, namely a failure to instate a proper system of training and supervision for the people who gave advice. So the House of Lords, though, took a different view, and one which was more favourable to insured. They held that it didn't aggregate. And Lord Hoffman stated very clearly, well, that although some aggregation clauses refer to an originating clause in the way Graeme's taken you through, whether that was the relevant unifying factor always depends on the facts of the case and the language of the clause. And in Lloyd's TSB, the language of the clause, and in particular its use of the phrase act or omission, that being the one we have in the minimum terms and conditions 2, showed that insurers were not willing to entertain something more remote or some more remote causal relationship to the claim than the act or omission that actually constituted the cause of action. So on that basis, said, well, the Court of Appeal were right that a single act or omission had to be a cause of had to be the one that caused the cause of action, but wrong to suggest that it could qualify as a unifying factor simply on the basis that they all arose out of the underlying failure to give training. Lord Hoffman held that if one extended the reasoning, well, I'll set out what he said. So Lord Hoffman's view was that instead what one had to have as a position is that wherever claims could be said to have arisen out of acts or omissions that together form part of a related series, and if those acts or omissions could all had to be said to be capable of having caused the claim. So he made clear that he wasn't saying that that meant that it was enough that one act should have resulted in one claim or another act in another claim. That provided no common causal relationship. The acts or events form a related series if together they cause one claim. So one is focusing on the actual claim, not some originating cause behind it, and all the claims together need to be responsible for the claims that are brought against the insured. Now, following Lloyd's TSB, the minimum terms and conditions were amended in the way I've suggested to put, or referred to put in 3 and 4, but significantly were not amended to introduce an originating clause unifying factor as an alternative, or something similar. But commentators suggested at the time that the fact that one didn't have brackets around one series of related acts or omissions, it was set out differently, might, among other things, be a distinguishing feature that set the MTC apart. And that, the case of Baines and Dixon, Coles and Gill saw the Court of Appeal grapple with that, and, well, does Lord Hoffman's interpretation in Lloyd's TSB apply to the minimum terms? And he held that it did. And some of you may know the background to the case. It involved what was referred to as the quite staggering dishonesty of the former senior partner of the insured firm, Mrs. Linda Box, who between 2002 and 2015 stole vast sums from multiple clients, mainly the estates of deceased people or churches, while simultaneously holding down senior offices in the Church of England herself. And she was subsequently sentenced to 7 years in prison after pleading guilty to dishonesty offences. And plainly lots of claims were then brought against the insured that together dramatically exceeded the £2 million of cover that they had. And insurers argued that, well, these claims aggregate because Mrs. Box's thefts were all part of a series of related acts. They formed part of an extended campaign of dishonesty, and they were all underpinned by her dishonest way of handling the client account. But that argument failed before the Court of Appeal. And they held, well, Lord Hoffman's interpretation applies, despite the slight differences in language. And on that basis, if one's applying that construction, it didn't matter that there was some underlying event, or underlying cause in the form of Mrs. Box's dishonesty, that wasn't sufficient to act as a unifying factor. What one was concerned with was with the individual acts and whether they could be said to form part of a series. And Lord Justice Simon actually paraphrased Lord Hoffman's test in a way which is perhaps clearer, and making absolutely clear what this clause in the view of the courts requires, which is if there is a series of acts A, B and C, it's not enough that Act A causes claim A, Act B causes claim B and Act C causes claim C. What is required is that claim A is caused by the series of acts A, B and C. Claim B is also caused by the same series and claim C too. Because what one has is a claims that arise out of the series of acts, and that was a word emphasised by Lord Hoffman. And one could see if one looks at that test, it's going to be a pretty rare case that's going to satisfy it. So going then on to 3 and 4 in the minimum terms and conditions clause that's permitted, well, these each have 2 essential elements. Both of them require a series of related matters of transactions, but 3 requires the relevant acts to be the same, while 4 only requires that the acts or omissions should be similar. Well, what's meant by the same or similar? Graham's touched on that already, but there's been particular authority on that in the MTC. Same is pretty straightforward conceptually. It's obviously not the same act, not a single act. One's looking for different acts that can be said to be identical, not just similar. As to whether acts or omissions can be considered similar, Graeme will look at that. That was an issue in Discovery Land, and an important issue was decided against insurers. But prior to that, there had been some guidance at first instance in AIG and Woodman. And as I'll look at that case briefly because it also deals with what amounts to a series of related matters or transactions before Discovery Land. So as with so many professional liability cases, AIG and Woodman is a story of shattered dreams. It concerned the development of 2 holiday resorts, one in Turkey and the other in Morocco. And the insured solicitor established and acted as trustee of a trust for each development separately that was supposed to have a charge over land or own the land. And the claimants were the investors who advanced the funds to the solicitors that were not to be released unless and until a cover test was met, which namely that the value of the assets that were held by the trust was sufficient to cover the investment. Again, as so happens in professional liability cases, reality was rather different than the theory. The developers entered an agreement to purchase the Turkish site, an agreement to purchase the shares of the Moroccan site, and after that the solicitors released the funds, but neither of those agreements actually completed. The developers were unable to complete the sites were not completed, and the developers were wound up, and investors brought claims against the solicitors in relation to each site that together totalled more than £10 million. Solicitors' indemnity limit only £3 million. And insurers sought a declaration that all the investors' claims aggregated on the basis that they arose out of similar acts or omissions in a series of related matters or transactions. Now, no particular issue is the similarity. At first instance, Mr. Justice Tier held that the word similar meant that there must be a real or substantial degree of similarity, as opposed to a fanciful or insubstantial degree of similarity. And applying that test, he said, well, the acts here were sufficiently similar. The developer could not pay out the vendors to complete the purchase because the defendants had failed to provide effective security. And as a result, after the investors' monies had been released, the investors were exposed to loss. Nothing particularly controversial in those set of facts. In contrast, the question of whether the additional requirements, the need for these acts to have taken place in a related matters or transactions, went to the Supreme Court. And giving the judgment of the Supreme Court, Lord Tilson stated that the use of the word related here implies that there must be some interconnection between the matters or transactions, in other words, that they must in some way fit together. And then he pointed out, but the Law Society saw fit after market negotiation not to circumscribe the phrase a related series of matters or transactions by any particular criterion or set of criteria. Determining whether transactions are related is therefore an exercise of judgment, not a reformulation of the clause to be construed and applied. Otherwise, there are no criteria. I'm not going to help you with what the criteria are. We're just going to decide in what he openly said was a highly fact-sensitive exercise. So not the world's most helpful, although unimpeachably right, not very helpful for anyone who's wanted to advise someone as to what the outcome of a case might be. But applying that approach, the Supreme Court said, well, the claims to the Moroccan investors on the one hand and the claims by the Turkish investors on the other hand, each separately arose from acts or omissions in a series of related transactions. The members of each group were separately investing in a common development. Monies have been granted in combination to achieve a particular end. They're all part of a standard scheme. They're all co-beneficiaries under the same trust in those two groups. And taking those points together, there was an underlying common objective that meant they fitted together factually. They also fitted together legally through the trust structure. So AIG and Woodman makes clear that the last two subclauses of the MTC require the application of, I think one could politely describe it as an open textured judgment-based test of whether the transactions fit together in some way, which is highly fact-sensitive. That being fact-sensitive, what one really is after here and would value is authority and guidance as to how that applies in particular sets of facts. One has Woodman, one now has Discovery Land. It's of particular premium, obviously, because so many insurance disputes don't come before the courts and aren't considered by judges and aren't reported or ever disclosed, but dealt with by way of arbitration. But that's the position as things stood before the decision in Discovery Land. I'll pass back to Graeme.
Thank you.
Right. My last 10 minutes is somewhere between a rant and an analysis of where I think things have gone a bit wrong. I'm going to start with 4 decisions. Then actually we've mentioned all 4 of them already to a greater or lesser extent. And I'm going to end up saying that I'm sure each of them are absolutely right on the MTCs as they stand, or Spire Healthcare away from the MTCs. But actually when one stands back and say, really? You might take a different view. So looking at AIG and Woodman, you've just heard from Miles, Lord Toulson's analysis, far cleverer than me. I'm sure he reached the right answer. But is it really right that just because Mr. Jones bought plot A in the Turkish development and Mrs. Smith bought plot 200 in the Turkish development, that the matters that gave rise to their claims were related, but the fact that someone else bought a different plot in the Moroccan development is not sufficiently related? It did seem to me that it was slightly intellectually dishonest to take that approach. Either the relation arises because of similarities, or it arises because actually Mr. Smith and Mr. Jones's transactions really were related to one another. But neither appears to have been the case in Woodman. Then you turn to Bishop of Leeds and Dixon, Coles and Gill. Again, you've already heard sustained and repeated thefts by Mrs. Box. I touched on earlier how Spire Healthcare found that in non-MTC wording, dishonesty underlying that sort of conduct, in the case of the surgeon, was a sufficient unifying factor to entitle insurers to aggregate on consequent or attributable to one source or original cause wording. Not so under the MTCs, as Miles has said. Absolutely the right result on the MTCs, but again, would an outsider view that as a sensible outcome? And I'd just ask you to think about a number of scenarios. Let's suppose Mrs. Box had in fact exercised restraint for many years until there was enough money sitting in one client account that she could steal 5 million in one go. £2 million policy limit, insurers turn around and say, well, it's plainly one claim, here's the policy limit, bad luck, insured, you have to stump up the balance of 3 million. Can't argue with that. Let's suppose now Mrs. Box had exercised slightly less self-restraint and in one policy year had stolen 2 million and then a few weeks later had stolen another 2 million. Insurers are liable in those circumstances for two millions. They're not liable for the balance of the million. Insured does that, does it himself. But just because Mrs. Box has stolen her 5 million in a series of small amounts, we get a completely different outcome. And I do ask, well, what's the difference in practice? Absolutely right. The MTC says there is a difference. But actually, if one stands back, is it the case that, well, bad luck to the person who leaves 10 million sitting in a solicitor's client account, but otherwise you're absolutely fine if the amount you've got in there is less than the policy limit? As I say, Court of Appeal tells us doesn't matter. Spire Healthcare, I've already looked at. I'm not going to say anything more about that because actually I think, and I'll come back to this in a moment, when you get away from the MTCs, it's much easier to reach what I'm going to call the right result, a sensible result that someone can actually justify. Discovery Land, I did see that there was someone from Axis on the guest list. Is anyone from Axis in here? Right, jolly good. I think Axis is desperately unlucky. My understanding is that application's been made for permission to go to the Supreme Court, that they haven't yet heard one way or the other. But at the moment, what the Court of Appeal says goes. Again, we haven't touched on Discovery Land, so just a few minutes on the facts, which are quite remarkable. Mr. Jones was the controlling mind of a group of companies, including a solicitor's firm called Jaya House, so Jaya House entities. He had a sidekick called Mr. Prentice. There was an Arizona development company called DLC who had the misfortune to instruct Jaya House in connection with their purchase of Taymouth Castle in Scotland. And in due course, they transferred $14 million into the Jaya House client account. Mr. Jones used roughly 10% of that to pay the deposit to the vendors, but the balance found its way from the client account into his own or accounts operated by his own companies. When it came time to complete, Mr. Jones told Jaya House that there were money laundering issues over the source of their original funds, so please could they send another $9.3 million, which they, from unimpeachable funds, which they did, against the background of undertaking from Mr. Jones that Jaya House would repay the 9.3 million from the tainted source of funds within 2 days. And surprise, surprise, that didn't happen. If that wasn't enough, the vehicle that the development company was intending to purchase the castle, it was called RTC, was said by Mr. Jones to give the game away as to who the who the purchasers were likely to be. So he suggested interposing a company of his own as a front company so that the vendors wouldn't work out who the purchaser was. And he's obviously very persuasive, Mr. Jones, because the clients went along with it. And then having done so, Mr. Jones trotted off to a lender called Dragonfly and got a loan of £5 million secured against the castle. And that £5 million went in his client account and then from his client account to another one of his own companies. And so the Arizona developers are out of pocket, firstly to the tune of 9.3 that they've sent over a second time, and secondly, the property's got a £5 million charge registered against it. They're not happy. So they bring two claims, one to recover what was called the surplus funds claim, the 9.3 million, another to recover the value that needed to be reimbursed to Dragonfly, the lender, to pay off what was called the Dragonfly loan claim. Gosh, that's not easy to say. So two issues at trial. The first is whether, reintroducing the sidekick, Mr. Prentice condoned Mr. Jones's dishonesty because they were the only two individuals there, and had he done so, the dishonesty exclusion would have applied. I don't know if any of you were at Alison Padfield's and Dermot Laffen's talk this morning. They addressed that. Suffice it to say, the judge concluded that Mr. Prentice hadn't condoned Mr. Jones's dishonesty. If you read particularly the first instance judgment, you might think that's quite a surprising conclusion. But that's what he found, and the Court of Appeal said, well, the judge was entitled to make that finding on the facts of the case. They stopped short of giving it a ringing endorsement, is probably the fairest way to put it. The second issue, though, is the one that concerns us, whether the surplus loan claim and the Dragonfly loan claim aggregated. First instance, Ms. Justice Tier said, no, they don't aggregate. Absolutely right, said the Court of Appeal, and said that for two reasons in a nutshell. The first is that the acts that gave rise to it, in fact, if I go back to, There we go. The acts that gave rise to the surplus funds claim were not sufficiently similar to the acts that gave rise to the Dragon loan claim. And it comes back to, I'm going to read out exactly what they said about each in a moment, but you might think that if they'd have asked the question slightly differently, they might have reached a different answer. The Court of Appeal said surplus funds claim was a straightforward misappropriation of monies transferred to Jaya House for a specific purpose. Well, can't argue that, or some might call it a theft. The Dragon loan claim, on the other hand, was the wrongful arrangement of a facility and a charge drawn down under the facility and then release of the money from the client account. Well, or other people might say it was a theft. They go on to say the claims are in substance about two very different things. Well, I genuinely don't believe that the Arizona developments would have looked at it in those terms. I don't think that the reasonable man in the street looks at those two states of affairs and say they are not sufficiently similar. They're not similar to each other at all, is what the Court of Appeal said. The Court of Appeal said it was oversimplistic to say they were both thefts. I think Patrick Lawrence, who collared me in the lift on the way up here, was put in his place when he described it as a distinction without a difference. And they said, absolutely not, Mr. Lawrence. So anyway, for what it's worth, I think Patrick's probably right on that. But the second reason the Court of Appeal gave was that the matters in which the relevant acts had occurred were not a series of related matters, and again, all matters or transactions. And that was because, and again I'm quoting, the Dragonfly loan was not in any sense part of a sequence of transactions in which the purchase of the castle was the first step. Well, of course not. The purchase of the castle was supposed to be the only step. And it does seem a bit artificial to say, oh, just because the Dragonfly loan, the Dragonfly theft I'm going to call it, was not the intended second step in a two-step process, it can't possibly be related to the first step. The castle purchase was only ever intended to be the only step, not the first in a sequence of transactions. And so by that logic, anything that happens afterwards can't possibly be related to it. And again, that just doesn't seem to me to be a terribly right outcome. I'm sure it's absolutely right in terms of the MTCs, but as I say, the correctness or otherwise from a is it the right result answer is rather different in my view. And as I said, I think if the Court of Appeal had asked themselves the questions a little bit differently, they could have reached very different answers, and intellectually it might have been more honest to reach those different answers. But where does that leave us, and where does it take us for the future? I think you can distinguish between, I'll call them solicitors' liability cases, but the reality is it's probably going to be any form of compulsory professional indemnity insurance case. Firstly, you've got a theme running through them all, and that theme is public policy. The principal purpose, and this is something from Discovery Land, the principal purpose of insurance cover against professional liability, namely the protection of that section of the public that makes use of the service of solicitors. And pretty much every case that we've looked at, and every case that you can look at that's reported in a compulsory professional indemnity context, the insurer loses out, the underlying victim of the negligent or fraudulent professional is compensated. And if that's the public policy, well, so be it. But that does leave insurers in really quite a difficult position, and I think will continue to leave insurers in a very difficult position going forward. Secondly, save in perhaps the simple case of multiple claims arising out of one act or omission or one matter or transaction, the hoops that need to be jumped through, and I won't scroll back to them, but the hoops that need to be jumped through to prove that the acts or omissions form part of a series, or that the same acts or omissions are part of a series of related matters or transactions, are really, they're hula hoops, they're tiny. It's going to be very difficult to jump through them, and we'll have a look at those three sort of common examples in a moment and think realistically whether there's any chance of them applying. But then thirdly, and it's something I've already touched on, because you've repeatedly got the appellate courts saying that questions such as whether acts and omissions are part of a series, whether matters and transactions related are, as Miles has said, acutely fact sensitive, well, you've got judges who will always be able to find facts that justify nearly always, be able to find facts that justify the conclusion that there's a not a series or not a sufficient relation. And the appellate courts will consistently say, as they did in Discovery Land, well, the judge was entitled to find that. And again, poor old Mr. Lawrence was criticised for what was described as island hopping, taking them to particular bits of evidence, with the court saying, no, you've got to stand back and look at it as a whole. And as long as there's something there, it doesn't matter that bits or even most of it might have put other judges the other way. And so where does that leave compulsory insurance cases? In those three common examples, similar mistake cases, the individual who repeatedly cocks up. Well, similarity of mistake alone is never going to be enough. You're going to have to jump through those tiny hoops of series and related matters. Widespread or repeated dishonesty cases, well, aggregation pretty much seems to be dead in the water, it seems to me, after the Bishop of Leeds case. And then cumulative breach cases, well, again, I really struggle to see how there's a future in that in light of what they found in Discovery Land, because it's going to be a rare case where cock-up 1 and cock-up 2 have that sequential relation, particularly where one or other would have resulted in either of the loss. You're looking at, whichever way around it is, so independent causes, and it is going to be a really rare case. So in terms of what the future holds for aggregation in solicitors' policy cases and other professional indemnity cases where it's compulsory insurance, I just can't see things changing from what's, I think, a pretty bleak picture for insurers at the moment until the MTCs are changed. And the MTCs aren't going to be changed unless the SRA softens its position a little bit. And the reality is, I would have thought that is not going to happen until the market reaches such a crisis point. Miles used the phrase of in the face of catastrophic group claims, as we were talking earlier, until that position becomes so extreme that there's no sensible alternative but to soften the MTCs a little bit. Other than compulsory insurance policies, compulsory indemnity policies, a much brighter prospect for insurers. Public policy reasons generally will not apply. They won't be used as an appropriate aid to construe the policies. The wording can, as we've looked at, and will differ considerably. It's up to each insured and each insurer to negotiate the bargain they wish to strike and to pay for it. And in those circumstances, there's absolutely nothing or no good reason why the courts won't continue to apply the broader wordings and the broader principles that we looked at earlier, and frankly ignore the MTCs, except when identical wording happens to be used by coincidence. How are we doing on time? Oh, sorry, we've run a little bit over. We've still got 5 minutes or so. That, I think, is everything we were going to say. If everyone would rather rush off to get a cup of tea or coffee, we won't take it personally, but if anyone's got any questions that they'd like to ask here, please do. Perfect. Well, we're going to hang around for the next 10-15 minutes anyway. So as you're all far too shy to ask them in public, do come and see us if you want to chat about anything. But thank you very much. So.